Hi, class and professor. Our podcast is about our case study. Our case study was about Danny K, who was falsely accused of raping a young girl. This case also involves Facebook and social media. Social media has not only provided a faster and easier way of globally networking with family and friends, it is also used for business and government purposes. Social media sites can be also a more modern tool used to gather data, used to track locations, run background checks, conduct civil or criminal investigation. It is one of the most convenient resources that can be used to access data and collect data for reliable evidence in legal matters such as civil court and criminal court. In many cases, searching digital evidence using social media has used to influence jury verdicts. Unfortunately, in many cases, the lack of knowledge and carelessness of the authorities harms innocent people in many ways. For example, Danny K of the city of Derby in the United Kingdom. Danny Stephen K was arrested and accused of raping a young girl in 2012. The girl provided to the police a series of edited messages from her Facebook account from the accused attacker Danny K, wherein he supposedly apologized for forcing her to have sex with him against her will. This evidence was used at a trial in 2013, and the jury rendered a guilty verdict where, upon the courts sentenced the accused Danny K to serve a prison sentence of 4.5 years. Danny K's rape conviction was quashed on December 21, 2017 by an appeals court after his sister-in-law recovered the original messages of the edited Facebook messages providing his innocence. As much as Facebook does appear to have a major role in this case, it does not. Facebook was founded as a social media platform in 2004. It was supposed to be a place where friends could connect and build profiles and share their stories about themselves, their families, jobs, journeys through life. And no matter how far they got geographically, they would only just one click away from each other through Facebook. However, over time, Facebook became a place to spread fake news, defame innocent people, scrape people's critical personal data, and use as a tool to cause harm, exact revenge, and rob funds from innocent people. This case was initiated in 2012, and there was an article from that year published London Daily Mail, which showed that citizens of the UK thought of Facebook. The article was titled, "Revenge? It's a dish best served on Facebook," was an editorial on how users target one another online. By Rob Priest, May 21st, 2012. To quote from the article, a significant portion of the British population had been surveyed, and of 2,000 Britons questioned, more than 2/3 said they thought social media such as Facebook and Twitter were responsible for acts of revenge becoming more common. 1 in 5 people said revenge was characteristic of modern life Britain, a statistic described as chilling by a leading sociologist, Professor Frank Webster. Webster said getting back at those who have crossed us and wreaking revenge is so much easier and instantaneous when it is involved with a social media such as Twitter or a Facebook slur. More than half said they were contemplating revenge, and 38% of respondents confessed to actually having targeted someone. Apparently, the police who arrested Danny K did not agree with the beliefs of common to a large portion of general population back then, because they set forth the Facebook messages as credible evidence. On July 28, 2012, a 16-year-old female reported that a 20-year-old Danny K had raped her. In UK, the age of consensual sex is 16, so she was out of legal age to consent to sex with a man. The young woman was categorized as a person A because in the UK, victims of a rape or sex offense are entitled to remain unidentified for life under the Sexual Offences Act of 2003. During his police interrogation, Danny said that he had seen A on 2 occasions. He admitted that during their second date, they had consensual sex. Danny K and the accuser had exchanged messages on Facebook before they met. After exchanging phone numbers, they met in person in February 2012. She said that in their first meeting, they sat in Kay's car and talked. The second time they met was at Kay's house. They were watching television on the sofa in the living room when he had sexual contact with her after she asked him to stop. She had provided the police with 3 pages of edited and misleading copies of the Facebook messages. The messages showed their plans to meet and so forth. There was nothing beneficial to Danny in those messages. Danny knew that the messages A provided were incomplete, but he was unable to find the original messages on his Facebook account. Therefore, he contacted Facebook for help to get back the messages, but Facebook never replied. During his trial in 2013, the jury saw a message that showed Mr. K apologizing for hurting his accuser. But messages in the conversation had been deleted and Mr. K had actually been apologizing for ignoring her. Another message suggested Danny had lied about his age during their first Facebook conversation. He asked the girl how old she is, to which she replied nearly 17. He then asks if she is single and she replies, "Yup." He says, "Same here." Yet in the messages shown to the jury, the reply "same here" applied only to make it seem like he is telling A too that he is 17. More critical are the numerous messages sent after the alleged rape that were deleted by his accuser. In one, Mr. K asked for her number because he had lost it. Not only does she willingly supply it, she complements it with 4 kiss emojis. Thus, it is proved that she did tamper with evidence to manipulate a trial and a jury into an unjust verdict or conclusion. The only thing that could be inferred from her behavior is that she was perhaps someone who could be described as a jilted lover who was out for revenge. Faced with a he said, she said case, the jury as trial sided by 10-2 majority with Kay's accuser and found him guilty on September 23, 2013. Kay was sentenced on November 11, 2013 to 4.5 years in prison. The complete set of Facebook messages which showed that no crime had occurred were recovered by Danny's sister-in-law, Sarah Madison, and she provided a statement to Kay's lawyer about what she had discovered. On March 2016, Kay filed an application for leave to file an appeal. Then on September 16, 2016, 2 years and 4 months after the original conviction and sentence, Kay's lawyer was finally able to prove that A had failed to provide the police the parts of the Facebook messages that showed the sex was consensual. When the new messages were shown to the court, the judges ruled that the exchange undercut the women's account and supported Mr. K's version. The court stated in its ruling in K vs. Regina, "We have come to the conclusion that in a case of one word against another, the full Facebook message exchange provides very cogent evidence both in relation to the truthfulness and reliability of A, who in any event gave a series of contradictory accounts about other relevant matters, and the reliability of the applicant's account and his truthfulness. We are satisfied that this further evidence does raise a reasonable doubt as to whether the applicant would have been convicted had it been before the jury, thus rendering the conviction unsafe. We also consider that there is, in the unusual circumstances of this case, a reasonable explanation for the failure to adduce the evidence at the trial. No retrial was ordered. Danny K stated, "I still can't believe it took years of stress and pain for this nightmare to end. The terrifying thought is that if the police and the justice system could fail me like this, it could happen to anyone. I couldn't believe how easy it was to find the messages," Sarah Madison said. "I've just worked in admin all my life, and I'm not a social media expert. It only took me a minute to find them. So how come the trained police couldn't do it?" Danny K's case had encouraged calls for a national review of all rape investigations, and this comes after 2 trials in London failed when it emerged that police had neglected to disclose crucial evidence that pointed to the defendant's innocence. Derbyshire police played one of the biggest roles in this case because they arrested Danny Kaye and removed him from his freedom based on the hearsay of the victim without any further investigation as to truthfulness, motive, and credibility on the part of the victim. This case is a perfect example of the professionals who are biased but perhaps not technologically competent with the internet software and apps used by today's generation, especially legal professionals. But they figured it out. Derbyshire police said, "We will be reviewing our investigation to find out whether lessons can be learned." Thank you all for listening to our podcast. I hope you guys learned something.